In 2018, global information security spending exceeded $114 billion. As online presence increases, so does the risk to privacy. Is the risk of a data breach inevitable, and who has the most to lose? The Privacy Act of 1988 defines personal information as information or an opinion about an identified individual or an individual who is reasonably identifiable, whether the information is true or not, and whether the information is recorded in a material form or not. The OAIC defines a data breach as the unauthorized access, modification, disclosure, misuse, or loss of personal information held by an organization. In 2017, the Notifiable Data Breaches Bill, or NDB, was passed in Parliament, providing guidance and actionable responses by organisations to a data breach. The NDB applies to data breaches that involve personal information which is likely to result in serious harm to an individual and is known as an eligible data breach. Mostly, data breaches are caused by types of malicious action, human error, failure in information handling, and security systems. Today, personal information is a commodity which can be shared, traded, and stolen. Recent examples such as Sony, Uber, JP Morgan, Ashley Madison, and the Australian My Health record system demonstrates that an individual's data is constantly under threat. Prior to the NDB 2017, companies utilised a non-binding, self-regulating code of practice that was intended to provide integrity on the use of an individual's data. The Association for Data-Driven Marketing and Advertising described the aim of their 2015 Code of Practice as a way to prevent the government from producing a heavy-handed approach to data laws. Without mandatory notification, an entity could cause harm to individuals without consequence and may result in significant risk to the integrity and trust of the online economy. Mandatory notification is a reactionary response and is only part of the solution. And without policing and prosecution, then privacy notification laws are a toothless tiger. There has been some effort by the government to introduce mandatory breach reporting. In 2013, the Privacy Alerts Bill was drafted with the intent to provide mandatory notification laws, but expired due to the cessation of RAD in September 2013. In 2014, the Enhancing Privacy Protection Bill was passed, which forced entities to responsibly manage information. In 2017, the Notifiable Data Breaches Bill went further by legislating mandatory notification of eligible data breaches. It is reasonable to suggest that the stall in legislation and law reform in Australia was caused by many factors. Who was going to police it? Could an under-resourced regulator keep pace with emerging technologies? Would the private entities show support or contempt for restrictive laws affecting their bottom line? And if so, what was the cost? Was it in the government's best interest economically? It really wasn't until large data breaches by large international entities and the increased use of emerging global mobile technologies that Australia felt their privacy and safety was at risk. This was becoming a global problem, and the Australian government was compelled to act. Australia has evened up the playing field with California breach and notification laws in recent times. The Attorney General's Office of California requires a business or state agency to notify any resident whose unencrypted personal information, as defined, was acquired or reasonably believed to have been acquired. The entity must issue a security breach notification of an incident involving more than 500 Californian residents and must submit a notification to the Attorney General. This must be achieved in the most expedient manner. By comparison, the Australian government law under the Privacy Act states that an entity must give notification if it has reasonable grounds to believe an eligible data breach has occurred. The entity must notify the individual if practicable. If not, they must publish a statement on the entity's website and take reasonable steps to publicise the contents of the statement. A full assessment of the MDB must be completed within 30 days. In conclusion, the current guiding principles for privacy have established a solid base, but without the willingness or resources of the regulator to police and prosecute organisations, then the integrity of an individual's privacy is doubtful.